Suppose the production of documents were ongoing during the transition from one to another. Everybody would just have to start over? This court cannot in good conscience facilitate such a result, and so as such, Big Fani's motion is denied. Signed and ordered on February 25th by Judge Shakura L. Ingram out of Fulton County. Fani loses again. Is Fani violating the law still? Remember, Fani's been disqualified from these cases, and is she still working on them? Fani Willis loses again, and oh, how sweet it is. This is another order that came out of Judge McAfee's courtroom. You see signed here by Judge Scott McAfee himself. This is the prosecution brought by Big Fani Willis, the biggest Fani in all of Georgia, against Kenneth Chesebro. He was one of the RICO co-defendants that was prosecuted with President Trump, and he signed a plea deal long time ago. Here you can see is the consent order for early termination of first offender probation. Oh, and what does it say? Kenneth Chesebro, by his lawyer, is now requesting a grant of early termination and a discharge of first offender probation status. So he didn't plead guilty to a crime per se. He pled guilty to a diversion offer. Put on probation as long as he completes that, there is no conviction. So he went through a change of plea process and did plead guilty, but it was held in abeyance essentially. But there was no criminal conviction. So the Fulton County DA's office does not oppose this request, said that he was placed on first offender probation on October 30th, 2023. We covered it. He's provided proof of completion of special conditions and probation to the district attorney's office. Now, as part of this consent order, Chesebro is withdrawing his other motions, which was premised on the prior ruling of constitutionality of the indictment, all this. So he was filing and fighting other charges. I don't need to do that. Judge says it is hereby ordered that Chesebro and his first offender probation is hereby terminated as of the date of this order. And it's further directed in accordance with the Georgia law, which we read through at the time, First Offenders Act, which allows a diversion deal, says that this discharge shall completely exonerate the defendant of any criminal purpose. Okay, no criminal conviction. Sorry, Fani. That this discharge shall not affect any of his civil rights or liberties. Got it. Sorry. No conviction at all. That the defendant shall not be considered, here it comes, this is the key part, shall not be considered to have ever had a criminal conviction. Ever. Not even when he went in there and did his change of plea to his first offender sentence. Look, never. Sidney Powell, Jenna Ellis, the rest of them, all the same thing. And that was in the paperwork from the very beginning. As long as you complete it, you'll never have a criminal conviction. Fani loses again. They got a little bit of money out of these people, a little bit of probation, but not a single criminal conviction has occurred. Not one. Sorry, Fani. This discharge may not be used to disqualify the defendant in any application or appointment to office in either the public or the private sector. Okay. So nothing has happened to him at all. And when we were here saying that when he took this guilty plea, because he did go through a change of plea, I've gone through this process with, 100 people. They all get a little freaked out at that last, am I pleading guilty to this? Kind of, not really. If you fail your probation, they'll drag out that change of plea proceeding and they'll hold this guilty plea against you and sentence you accordingly under that. But it's not in effect right now. This is all held in abeyance. You're going to just spend some time not breaking the law, come back, everything is going to go away like it never happened. Now that works out great for most people. Fani absolutely did not want that because she was running around telling us, lecturing us about threats on American democracy and blah, blah, blah. Then she gave them diversion deals and we were mocking her into oblivion back then. And turns out it's true. So we're vindicated. Says, wherefore it is further ordered and directed, Georgia Crime Information Center shall be notified of this discharge in accordance with the provisions of the said act as amended. Signed by Judge Scott McAfee and even the DA, Dacia Young. Oh, Fani didn't sign it? Why not, Fani? Oh yeah, because you're disqualified. You can see Fani loses again. No convictions are going to stay. And I just have to say, we called that one. So now you can see Senator Greg Dolezal is also explaining that Fani tried to fight a subpoena to subpoena her booty right into Senate. Yesterday, the judge agreed with the senators who sent the subpoena and denied Big Fani's attempt to quash the subpoena. So, you can imagine Fani quashes a lot of things just by existing. But she wanted to quash this subpoena harder than Nathan Wade, and she failed. No one is above the law, said Senator Greg Dolezal, and says, we'll see you soon, Madam DA. Here's what the judge wrote. Order denying the motion to dismiss. So Fani sent this one in. She said, I'm trying to quash this thing right now. She wanted to eliminate the subpoena. She wanted to stop the subpoena for documents coming her way. And here's what the judge wrote. This matter is before the court on Fani's motion to dismiss or to quash quash that application, quash it, to enforce the witness subpoena or the subpoena ducis tissum. Now, in short, Big Fani argued that the subpoena, the application to support the witness subpoena, is moot or void, right? She says, no, they filed a subpoena, it's moot. There's a new General Assembly and that the special committee ceased to exist. Okay, so like the election happened, that old committee issued the subpoena, there's a new committee here, and they don't have the power. Therefore, it lacks the power to enforce its subpoena. Judge says no. For the reasons set forth below, the motion is denied. Sorry, Big Fani. As an initial matter, the court agrees with the Senate that the authority that Fani cited does not stand for the proposition that the original subpoenas must be declared void because of a new assembly. And the special committee have been reconstituted post-election, and the cases cited by Fani in her motion are critically distinguishable for the same reasons set forth in the Senate's reply, which are incorporated herein. So in other words, Fani cited a bunch of irrelevant cases. Like, oh, well, this case supports me, and this case supports me. It's like, no, it doesn't. It's talking about like bankruptcy law in California. What are you talking about? Like, this is a Senate subpoena in Georgia. What are you taking us to California? What are you talking about? Over and over and over. Okay, obviously not that bright. Whoever was writing that one, I don't know if it was Fani or Dacia or whomever, but here's the other part. It says, moreover, this court agrees that regardless of whether the subpoenas are void, the dispute at issue is capable of repetition yet evading review. Meaning, if I dismiss this because of a new election and a new assembly committee, well, then they'll just get a new subpoena and then you'll just stall it out and then we'll just have another election and then you'll just say, oh, new committee again. And so nobody can ever get this done because if I accept your argument, we just go in this loop. So it's capable of repetition but evading review. So we're just going to hear it now. Now, while the court is not unsympathetic to Fani's argument that these particular subpoenas were served at the end of a term, thus reissuing them anew would afford more time for Fani to comply, the reality is that there are a myriad of ways to tie these disputes up in court. So Fani will just drag it out. If every time a subpoena is issued by a special committee, the recipient can simply litigate its validity and enforcement until the General Assembly reconstitutes and then start this all over, that would be an absurd result indeed. We're not going to do that. Not least because this would mean that if the need for a subpoena did not arise well towards the beginning of a term, the General Assembly would be forced to defer its subpoena until the beginning of the next term to try to enforce it. And so this could and would result in lost evidence and fading memories and disappearing text messages and receipts and cash under mattresses and all sorts of stuff. So general inefficiency as well. So moreover, suppose the production of documents were ongoing during the transition from one to another. Everybody would just have to like start over. This court cannot in good conscience facilitate such a result. And so as such, Big Fani's motion is denied. Signed and ordered on February 25th by Judge Shakura L. Ingram out of Fulton County. So Fani loses again. Now, some other items that we had seen clipped from our friends Phil Holloway. Is Fani violating the law still? Remember, Fani's been disqualified from these cases, and is she still working on them? Phil asks, is she violating that order of the Georgia Court of Appeals which booted her? She's still filing pleadings. All she can do is appeal. That's it. Now, he cites this footnote. Says the Court of Appeals could not be more clear. Not only is Fani disqualified because of the significance of appearance of impropriety for indicting her lover, but so too are the assistant DAs. They're all disqualified. Their only power to prosecute a case is derived from the constitutional authority of the DA who appointed them. So the assistant DAs, along with Fani, anyone who filed the petition for a writ must be disqualified. Okay, so her whole office is disqualified. And I don't know who signed that consent order from Fani's office, counsel for the state of Georgia. Don't know if that was from Fani's office or not, but she should not be working on the case. She's disqualified. In Georgia, they're now passing or working to pass a new bill for the judiciary, SB 244. It would provide for the award of reasonable attorney's fees and costs in criminal cases if you're charged with the crime, if you show that Big Fani was indicting her lover or any other misconduct in connection with the cases. So if you're being prosecuted and your prosecutor is creating evidence because they're in love with their special counsel and they want this grift to continue on so he can continue to get paid, so they can continue to go on cruises together and have their 2-hour-long meetings together at work. All of that, if it happens to you, you get attorney's fees for your fake prosecution, and you should get damages, treble damages out of Big Fani. So Fani continues to lose. We continue to cover it, and we're going to do so until justice is done. Thank you for subscribing and joining as we do, and we'll see you right back here on the next one.